I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, I am bringing you compilation number 102, and we're going to be focusing just on one judge today, and that judge is going to be Judge Kenneth King out of the state of Michigan. Judge King is going to have three different sovereign citizens before him today, three different sovereign citizens that we featured here on the channel. And one of these sovereign citizens you guys are very familiar with by the name of Mr. Albert Hicks. Very disrespectful, very aggressive. We seen him, him and Perkins, Judge Perkins go at it, and Judge Perkins had to tell him, don't let this robe fool you. So we know that Mr. Albert Hicks can be a handful. But on this compilation, him being before Judge King, very serious charges, different type of atmosphere. We're going to see a different type of Mr. Albert, but very serious charges. We're going to play that at the end of this. But nonetheless, we're focusing on Judge King today. There will be no commentary added to this. There will be chapters added for your convenience. I appreciate you guys always for joining me here at Sovereign Citizens Hall of Fame. Don't forget to like, comment, share, subscribe. You know that it helps us out. And listen, let's go ahead, guys, and jump into Judge King's courtroom.
Judge, I just spoke with Ms. Moses. She's not available to Zoom in right now, so I can stand in.
Okay. Guess we're ready on Pollard.
Calling case number 2405-538-101, people of the state of Michigan versus Captain Pollard. Defendant charged in count one, criminal sexual conduct of the second degree.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249. I'm standing in for the attorney of record, Assistant Prosecuting Attorney Erica Moses.
And good morning, Your Honor. Nicole James, appearing on behalf of Mr. Pollard. My P number is 58961.
All right. What's your pleasure, counsel? Oh, Mr. Pollard, unmute yourself and tell us your name, sir. Mr. Pollard, have them unmute you so you can tell us your name. Tell me your name, sir.
I exercise my right to remain silent.
You don't want to tell us your name?
I'm the beneficiary.
Beneficiary of what?
Of the trust that we are now here to administrate.
Okay, that's fine. Can you tell me your name?
Excuse me?
Can you tell me your name?
The beneficiary of the trust, Your Honor. I'm not
beneficiary of trust.
I'm not coming here as the name. I'm summoned as the state trust. It'll be a contradiction.
I'm looking for Kevin Pollard. If he's not here, I will capious him.
Your Honor, you are appearing as Kevin Pollard today.
No, I'm not. My name is Kenneth King.
No, Your Honor, you are the trustee of the administrate, the trust that we are now here to administrate. It is a
I have no idea what you're talking about, sir. I'm just looking for Kevin Pollard. If you're not him, then I'll issue an arrest warrant for Kevin Pollard because he's supposed to be here.
Under trust law, it's a contradiction for one to be the beneficiary and the trustee, Your Honor.
All right, you're talking a different language to me. I have no idea what you're talking about. Miss James, how would you like to proceed?
Judge, originally I was going to ask it to be set for a preliminary examination, but it sounds like it may be a competency issue. So Judge, what I'm going to ask the court to do, I have an appointment to meet with Mr. Pollard this afternoon. I'm going to ask the court if you would, we can set an exam date, but we could also set Monday as a review date.
Okay, why don't we just do that before we set an exam date?
Okay.
court will adjourn the probable cause conference. If you're able to find Mr. Pollard, we'll adjourn the probable cause conference to February 5th at 8:30.
Yes, Your Honor.
Find Mr. Pollard, and I will issue a case for his arrest. Thank
Yes,
you.
Your Honor. Thank you. Have a good one,
Thank you,
everyone.
Judge.
Sir, in the Wayne County Jail, what's your name?
There you go.
Say your name.
Say your name, sir.
For me,
Yeah.
the beneficiary of the state. I'm here today for the state.
What's your name, sir? I don't know who the beneficiary is.
Excuse me?
What is your name?
I'm coming to appear as the beneficiary of the state, Your Honor.
Okay, forget all that. What did your mom call you when she named you? I have no idea who you are, sir. Okay, well, you're gonna sit there until I figure out who you are.
I'm not under that jurisdiction to consent to the name, Your Honor. That's appearing
As
under
far
your
as I'm concerned,
jurisdiction.
your case is then, because I'm looking for Mr. Pollard. If you're not Mr. Pollard, then you're not here, and the warrant will be for your arrest, and you can sit in jail till you rot for all I care.
That's fine, Your Honor, but
Okay.
that's,
Deputy, you can remove him, he's not here.
he's not here today because he doesn't exist.
Okay, bye.
The all
Have a nice
caps,
day.
the all caps entity.
Good talking to you, goodbye. Ms. Drain, I have Ms. James here on Pollard. That said you were standing in for Erica Moses.
Yes.
Okay.
Yes.
Ready? All right, ready on Pollard.
Calling case number 240-55381, the people of the state of Michigan versus Kevin Pollard. Defendant is being charged with count 1, criminal sexual conduct, second degree. Person number 13, defendant 17 years of age or older. Sore notice. Today is the date and time for
Please remove your sunglasses.
appearance.
Appearance for the record, please.
Good morning, Your Honor. Shelley Drain for the people, number 60249.
And good morning, Your Honor. Nicole James, appearing on behalf of Mr. Pollard. Judge, I would ask to waive his presence if he is not in the courtroom. He is in the Wayne County Jail.
Court will waive the defendant's presence. Today's the date time set for a competency hearing. Did you get anything back from the forensic center?
Yes, Your Honor. The report indicates that Mr. Pollard is competent.
Are you stipulating to those findings?
I am, Your Honor.
Okay, the court makes a finding that the defendant is competent to stand trial. What's your pleasure?
Judge, we would ask that it be set for a preliminary examination date.
Court will continue the plea of not guilty and set this matter for a preliminary examination. How is March 27th at 12:15?
Judge, I'm out of town all next week. My first available date would be April 4th.
That's gonna be a problem, Ms. James, because the court is, that's my homicide day, and the court is closed April 5th.
Okay. Well, Judge, I'm out of town all next week, and then on April 1st, 2nd, and 3rd, I'm in a trial in Ann Arbor.
April 8th, that's my last offer.
April 8th is a good date.
April 8th
What
at 10
time?
o'clock.
10 o'clock, yes.
Bound to be continued.
Okay. Thank you, Your Honor. Have a good one, everyone.
You too.
How you doing, Mr. Pollard? Yes, sir. Thank you. He's not finished yet. Just order next to your time.
Calling case 2455381, people of the state of Michigan versus Kevin Anthony Pollard. Defendant was charged with count 1, criminal sexual conduct, second degree, person number 13, defendant 17 years of age or older. Appearances for the record, please.
Thank you, Your Honor. Erica Moses on behalf of the people, 78491.
And good morning, Your Honor. Nicole James, hearing on behalf of Mr. Pollard.
Kevin Pollard.
All right, today's the day time set for preliminary examination. Are the people ready to proceed?
Your Honor, I am not. I contacted the court via email as well as Ms. James to let the court know that Ms. Alexander Grayson and her daughter Nayla are out of state this week. They will be back on Friday. She said she'd be available then or anytime next week, Your Honor. And I do apologize. They are on board prosecuting. They will be present. They just cannot be present today as a short term.
Judge, I would indicate that we were last here on March 20, and the preliminary exam date was set on that date. I would indicate that the prosecutor did send an email out on Thursday. Judge, I do not believe that is good cause. This date has been set for some time. I would ask the court to dismiss this case without prejudice.
Wait a second. Mr. Hicks. All right. So I'm gonna make sure Mr. Pollard knows exactly what's going on here. So Mr. Pollard, when this court set the date for the preliminary examination, that date was set without the people contacting planning witnesses at that time. Sometime after you found out, and the witnesses prepaid the trip on the time. Although they're not here, they are interested in going forward with this. So this court can find good cause to adjourn the matter to the date that they're not back or otherwise unable to proceed the case. Court also has the option of dismissing this matter right now. But as people indicated this, they have complaining citizens that are still interested in going forward with this matter. The case will likely be reissued, which means we could be rearrested again, and we have to start this process all over again. I look at your face, I know you don't want that either. Yes. So I'm inclined to go ahead and give them to Friday to present their witnesses and go forward. If they're not able to do so, in this case,
Judge, I'm not available on Friday.
no time Friday.
No, Judge.
I can do it.
16th or 17th?
Excuse me?
The 16th or the 17th?
Can't do the 16th, that's my homicide day. Not available on the 15th.
Judge, I have a full docket on the 15th. One of the reasons is because I have a jury trial set for tomorrow, so I have to fire on everything.
Okay, we can do April 17th at 10 o'clock. We'll find good cause for the adjournment.
Thank you, sir.
On case 24-55381, for State of Michigan versus Kevin Deron Anthony Pollard. Been discharged in count 1 criminal sexual conduct, 2nd degree. Person number 13 is in 17 years of age or older. Prosecuted right here. Pollard, we're gonna have you have a seat in the second row until the witness comes to the court.
Sure. Sure, sir.
Did I get the appearances already?
Thank you, Your Honor. Erica Moses on behalf of the people from 78491.
Good morning, Your Honor, Nicole Jones, on behalf of Mr. Pollard, P5896.
Pollard, tell us your name for the record.
Stand up.
Tell us your name, sir.
Stand up.
There's a date time set for preliminary examination. Are you ready to proceed? She be on again?
She went to get the young lady
Let's
first.
get her some roller skates. Are you people ready to proceed? It looks like it.
Yes, Your Honor, if I just have one moment.
You doing? Sorry.
Just before we begin, she wanted it on the easy course, she could ID anybody, otherwise she wasn't going to begin. So she just wanted to look around first, and now she's going to bring it back.
Thank you, Judge.
Hello.
May we approach one more?
Okay.
Uh-huh. You're wrong now.
Okay, we're back on the record.
Thank you, Your Honor. The people did have one witness here, the complainant in this matter. I do have an issue moving forward at this time. I do plan on rewriting. However, I need to get an out-of-state witness here in order to proceed.
Your Honor, with that in mind, we would ask this case be dismissed.
So order the court will dismiss this matter without prejudice.
Judge.
Dismiss the order, Mr. Mayor.
Yes, Your Honor.
What's your name, sir?
Raymond Terrell.
Okay, come on, Mr. Reed. I'm gonna have you stand right here in front of this seat, okay?
Calling case 2359278. People of the state of Michigan versus Raymond Terrell Bland. Defendant is charged in count 1 with. There is.
Count 1, weapons carrying concealed. Appearances for the record, please. Agent Lewis for the people, P85520.
And it looks like the defendant has not been assigned an attorney. What's your name for the record, sir?
Raymond Terrell.
It's Raymond Terrell. So it looks like you got Raymond Terrell is your last name?
No, it's not.
What's your last name?
You asking me to name on my birth certificate? Name on my birth certificate is Raymond Terrell Bland. But it would be fraud for me to use that name. That name is copyrighted by the Queen. How could I possibly use that name?
Copyrighted by the Queen. What
Yes.
Queen? You don't have a
Queen
Queen.
of England or whoever, but it's copyrighted. It's owned by someone else. I don't own my name.
In any event, this matter is scheduled for preliminary examination. Sir, you don't have an attorney present here. The court wishes to assign you an attorney.
I'll deny it. I don't want it.
Why not?
I don't want an attorney. I don't need an attorney.
Think you're capable of representing yourself?
Yes, I am.
Are you an attorney?
No, I'm not an attorney.
How far did you go in school?
I went far enough.
How far is that?
12th grade.
Graduated?
No, I did not.
Okay.
I can read, write, and I understand proper English. So
All right, let me make sure that you understand me. I think that you're really doing a disservice to yourself by not having an attorney. And this is for your own protection because you're not charged with the most serious of crimes, but yet it still is a 5-year felony. Do you understand that?
yeah, I understand.
Okay. Do you understand that an attorney will be able to do some things on your behalf, like possibly get you diversion, to which you would plead guilty, do a short term of probation, and then the case would be dismissed off the record.
I understand my rights and I understand the situation that was going on. So if I would represent myself, whatever happens is what happens.
You understand that if you represent yourself, I gotta hold you to the same standard as if you were an attorney. I'm not cutting you any breaks because you don't know the law.
That's fine. I understand.
So it's your wish to represent yourself.
Yeah.
All right. Now, in no way mean to insult you in any kind of way. But you have heard of that old saying that anyone who represents himself has a fool for a client. There's a lot of truth to that. A lot of truth to that.
It's my right to represent myself, and I wish to represent myself.
Okay. Are the people ready to proceed?
Yes, Your Honor.
How many witnesses?
Just the one.
They call you witness.
At this time, the people call Officer Bashby.
Sit down, sir.
Your Honor, we ask for a mutual fee restoration with the exception of the officer in charge. Please take care.
All right. Take it there, please. All right, ladies and gentlemen out there in YouTube land, if you are a witness or potential witness, I'm ordering you to log off at this time. Sir, please step forward, give your name and spelling to the court reporter. Yes, Your Honor.
N-A-V. Last name B-A-J-P-A-I.
That's all.
Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor, I do.
Thank you, sir. Please have a seat. The witness box next to me. Voice up nice and loud and speak to that microphone. To the right.
Yes, sir.
You may begin when you're ready.
Can you please take your name and occupation for the record?
Officer Naveed Bashby, police officer with the Detroit Police Department.
And how long have you been a police officer?
Approximately 5 years.
And were you working in the capacity of a police officer on October 5th, 2023?
Yes, ma'am, I was.
Okay, and were you working by yourself?
No, ma'am, I was working with 2 partners,
What's their name?
Officer Ryan Ruloff and Officer Daniel Colgrove.
And on this particular day, were you working in full or modified uniform?
I was working in a modified uniform, as you see me in court today with.
Okay. And were you on foot patrol or in a scout car?
In a scout car.
Was that scout car police marked or semi-marked?
It was semi-marked.
Okay, and when a police vehicle was semi-marked, what exactly identified that as being a police vehicle?
It's present with decals stating Detroit Police on both sides. However, the light bar is inside the vehicle as opposed to on top.
Okay. And did your duties as a police officer take you to 1200 East 7 Mile Road?
Yes, ma'am, they did.
And is that in the city of Detroit, County of Wayne?
Yes, ma'am, it is.
And what is at that location?
That is a Bolero gas station.
Okay. And why were you at that location?
We were conducting a routine patrol in the area.
Okay. And while you were conducting routine patrol in the area, did you observe anything that caught your attention?
I did, yes.
What did you observe?
As my partner pulled the scout car eastbound through the parking lot of the Bolero gas station, I observed the defendant, Mr. Blanding, walking westbound through the parking lot of the gas station towards our oncoming scout car.
Okay. And can you please point to an identifier on the book code of the person you had identified that you observed?
That would be Mr. Blanding with the gray t-shirt.
Your Honor, may the record reflect that the witness has identified the defendant?
So no.
Okay. And upon making this observation, did you observe anything further?
I did, yes.
What did you observe?
As Mr. Blanding was walking towards us in mentioned manner, I observed the grip of a handgun protruding from his front waistband.
Okay. And based on your observations, what, if anything, did you do?
At that time, I exited my scout car to further an investigation for possible CCW.
Okay, and what happened next?
I made contact with Mr. Blanding in the parking lot. At that time, I asked him if he could present me with a CPL.
And did he present you with the CPO?
He stated to me that he's open carrying and therefore did not need it.
Okay, and upon receiving that information, what did you do next?
I instructed Mr. Blanding to place his hands upon his head in order to safely recover the firearm, which he did.
Okay, and why did you instruct him to do so?
Mr. Blanding had previously informed me that he did not have a CPL, which would be a requirement to carry a firearm in mentioned manner.
Okay, and when you say in mentioned manner, please explain to the court what do you mean by that?
The majority of the firearm was concealed within his front waistband. The only exposed part of the firearm was the grip.
Okay, and did he comply with putting his hands up and everything?
Yes, ma'am, he did.
Okay, and did the defendant have a CPO?
No, he did not.
And did you verify that?
Yes, it was verified via lien.
Okay, and what did you do with the firearm?
I secured the firearm as well as the inside the waistband holster inside my scout car, pending processing of the prisoner.
Okay, did you place that on evidence?
I did, yes.
No further question.
Cross-examine. You get to ask questions. Yes. To the podium so we can hear you. Right.
I asked you, what was the reason for stopping? What was the reason for stopping?
As I stated, I observed you concealing a firearm in the front waistband.
You observed me concealing a firearm. You can see the firearm properly from with your eye from the scout car, from 30 to 40 feet away, right?
As I mentioned, I could see the grip of the firearm protruding from your waistband.
Okay,
Yes.
so how could you consider that concealed if you can see the firearm with your eyes? And that's what, the only thing that made you stop me was the vision of my firearm, right?
A portion of the firearm.
Look, all you seen, but why else did you stop me? There was no other reason for you to stop me, so that would be considered a Terry stop, right?
As I mentioned, that was the reason for the investigation, the further weapons offense investigation.
But there was I was not committing a crime. There was nothing that you can say that I was committing a crime, or no other reason that you can say that I was doing anything wrong for you to stop. So you had, what would you say? You just had a feeling that I didn't have a CCW, so that is the reason why you stopped me.
No, sir, I had reason to investigate you and ask you to present your CBL card.
But what was the reason for stopping me? I was not committing a crime. I was walking through the stairs. You can see the gun. You don't know if I have a CPL or not. So what gives you the right to even stop me in the first place in question?
Because the majority of the firearm was concealed inside your waistband.
Once again, you don't know if I have a CPL or not, right? So why did you stop me? You don't know if I have a CPL or not. I'm not committing a crime. I'm walking down the street, so you have no right to stop me and question me in the first place. That is a violation of my Second Amendment rights.
Yeah,
Is that a question or a statement?
So
You have to ask questions.
So you can see that I was not committing any crime. So can you tell me what was the reason for stopping me besides the sight of my firearm?
That's been asked and answered.
Okay, so there was no other reason for you to stop me. I don't have any more questions. I mean,
Okay. Any redirect?
no redirect, Your Honor.
Thank you, sir. You missed it.
Thank you, Your Honor.
Any other witnesses?
No further witnesses, Your Honor.
Sir, do you have any witnesses to call?
no, I don't.
Your Honor, at this time, the people will request that the case be bound over. We do believe that this question of fact for the trier of fact to be here from the witness officer last time. He stated, upon observing the defendant with a grip of a handgun protruding from his waistband, he then went and investigated for possible carrying a concealed weapon, upon which he asked if he had a CPL. The defendant did not present one, at which point the officer recovered the handgun and made it safe, and also verified via lead as to whether he had a license to carry, and which he did not. So, Your Honor, the people believe that this question of fact or trier of fact based on
Mr. Terrell and Mr. Blanding, whichever the name is. Would you like to argue as to why the court shouldn't bind it over?
You say what?
Would you like to make an argument as to why the court should not bind this matter over?
Yes, I would.
Go ahead.
Because he violated my Second Amendment rights. I have a right to bear arms, and I was doing nothing wrong. I did not commit a crime. He did not have a reason to stop me in the first place. That would be considered a Terry stop because he didn't have a reason or a right to stop me. I was not committing a crime. So why did he even stop me and approach me? I have a right to bear arms. My arm was legal. It's registered. So therefore, why was he even stopping me? That's harassment. He stopped me because he seen a black man carrying a firearm walking out of the store. There was no other reason in the world he could stop me. I don't see no other reason why he could stop me. Like, I was not committing a crime. Usually you would have to be committing a crime for someone to stop you if you're walking out the store. Well, the only thing he's seen my pistol. I have a right to carry a pistol. That is my Second Amendment right. So why is he stopping me?
All right, I get what you're saying. And that's not different than an argument that an attorney would make. You didn't do too bad, especially to not have any formal education in law or college and life. But let me explain something to you. You do have a Second Amendment right to bear arms, but as all of your rights, none of those rights are absolute. States have been made to regulate how and when you can carry a weapon. In the state of Michigan, although you can open carry, you cannot carry a concealed weapon. Hold on, let me talk. You cannot carry a concealed weapon on your person without a license to do so. Sir, please do not interrupt. Let me talk. I'll give you another opportunity, okay? All right. So the officer testified that the weapon was concealed on your person. It wasn't totally concealed in that he could see the hand grip of the weapon. It does not have to be totally concealed in order to be concealed in the state of Michigan. A portion of it, he said that the only part that was visible was the grip of the handgun. That would be considered concealed, or at least a question of fact as to whether or not you were open carrying or carrying a concealed weapon.
The only thing that I can say that would be the problem is I had an Empire holster. I wasn't aware of the holster.
Your holster isn't even an issue.
Yeah.
I don't have a problem with you having a holster. I don't have a problem with you carrying a gun if you're open carrying.
Yeah, open carrying. But the reason he seen the gun, Your Honor, is that's the only reason he seen it. When I walked out of the gas station, he can see it with full view. How can you consider that concealed? That's out for him to see.
Because a portion of the weapon was concealed. You can see that the portion of it was concealed. You had an inner holster, right?
Yes.
So with the inner holster, because I carry one myself, with the inner holster.
Like a quarter of the gun is concealed and the rest of it is hanging out.
Well, I don't know what kind of gun it is, but a quarter of a gun or half the gun, he said that most of the gun was concealed.
The majority of the gun was out. If you can see the video from it, you can see the gun and you can see how much of the gun was hanging out from the video.
All right. So you'll be free to argue that even if this gets to trial, that the gun was not concealed. But based on his testimony, his sworn testimony, he said that the majority of the gun was concealed. The only thing that you could see was the handle of the gun, and that's what he observed. Now, possessing the gun on your person gave him reasonable suspicion that you might be carrying the gun without a license. And that's what he acted on. He went in to further investigate whether or not you had a CPL.
That was like a hunch though. That's like he couldn't say for sure.
That's what reasonable suspicion is.
A hunch, and that gives you the reason to stop me. If you don't know how I'm committing a crime, for sure he shouldn't be able to stop me.
Reasonable
Maybe.
Reasonable suspicion. You mentioned the case Terry versus Ohio. You might want to go read. Reasonable suspicion means that you have reason to believe that criminal activity might be afoot, and that you can articulate on the record what that reasonable suspicion is. He saw you with a gun that was somewhat exposed on your person. Based on that, he could come and ask you questions to see if you were carrying that gun legally or not. Based on his testimony, he did so and you were not. So that's where you stand. All right. So the court, after hearing the testimony of the officer, is satisfied that people have met their burden of probable cause as it relates to the charges contained in the complaint warrant. The court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this defendant committed them. The defendant will be bound over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information, date and time will be February 15th, 2024 at 9:00 a.m. Bond will be continued.
Ready, Draw.
Okay, we can call it.
Calling case 230-601-1701, the people of the state of Michigan versus Albert Hicks. The defendant is charged with count 1, assault with intent to great bodily harm, less than murder or by strangulation. Count 2, domestic violence, aggravated second offense notice. Today, date and time for an examination. Appearances, please.
Good morning, Your Honor. Madison Oro on behalf of the people, requesting information under MCR 8.120P under the supervision of Attorney Shelley Drain.
Attorney Monica Sanford, P6. Attorney Monica Sanford, P62315 on behalf of Albert Hicks.
Today's the date and time set for preliminary examination. Are we ready to proceed?
Your Honor, the people are ready to proceed.
How many witnesses for the people?
One witness, Your Honor.
And Mr. Hicks, tell us your name for the record, sir.
Say your name.
Albert Heimer Hicks Jr.
All right, call your witness.
The people call Ms. Kimberly Hubbard to the stand.
Give your name and spelling to the court reporter. Okay, stand closer to the podium so I can see you and raise your right hand. Back towards the podium where the prosecutor is. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please have a seat in the witness box next to the bench. Keep your voice up nice and loud and speak into that microphone that'll be to your left. You may begin when you're ready.
Thank you, Your Honor. Can you please state your name for the record? Kimberly Hubbard. Thank you. Ms. Hubbard, I want to draw your attention to November 22nd, 2023. Where were you on that day?
At my house, 18212 Strathmore Street.
Okay.
Detroit.
So you just said that's in Detroit. That's in the county of Wayne?
Yes.
Thank you. And did something happen on that day that brings you into court today?
Yes.
What happened on that day?
I was assaulted by Mr. Hicks.
Okay. So you stated you were assaulted by Mr. Hicks. Is that Albert Hicks?
Yes.
Okay. And how do you know that person?
He was my partner, and he is the father of my children.
Okay. How long were you guys partners for?
Around 14 years.
And do you see that individual in the courtroom today?
Yes, I do.
Can you please point to him and identify a piece of clothing that he's wearing?
Yes, he has on a black vest.
Thank you. Your Honor, please let the record reflect that the defendant has been identified.
Noted.
So going back to this assault, as you stated, can you just explain to the court in a little bit more detail what occurred?
Well, I worked a 12-hour shift that day. I worked for a before and after school program. So I work from 6:30 a.m. to 6:30 p.m. I get off of work. I get in the car with Mr. Hicks. He drives me to and from work. I get into the car. I can tell that he's a little upset. So we're talking, and he begins to argue about some things from the past, jobs that he was owed for in the past. So that's how the argument started. I didn't really feed into the argument. I wasn't trying to respond to the argument. It was just kind of, let's just get home.
Okay.
So we end up pulling into.
I'm gonna stop you right there, I'm sorry. I just want to, ask you a few questions about what you just stated. Okay, so just to clarify, Mr. Hicks picks you up, takes you and picks you up from work.
Correct.
Okay, and on this date, November 22nd, he was picking you up from work?
Correct.
Perfect, and you got into the vehicle with him, and, you stated there was an argument, right?
Yes.
Okay, and so you were going into a little bit detail, sorry, about, what the argument was pertaining to, and so can you state that again? What the argument
It was about a prior, job that he had done. He just home improvement. It was a prior job that he had done that he wasn't, properly compensated for.
Okay.
That he says he wasn't properly compensated for, which I had nothing to do with.
Yeah. Okay, so after he is, expressing these things to you about these, different jobs that he hasn't been properly compensated for, what happened next?
He just kept yelling, "Oh, I'm gonna get my money." The job he is referring to, he had done for my current employer. So he felt like I had something to do with that, but I had absolutely nothing to do with that. So I just wouldn't feed into it because that has nothing to do with it.
I understand. So, earlier in your testimony, you stated, that Mr. Hicks assaulted you. So at what point did this, argument between the two of you turn physical?
Once we got to the residence, which is the Strathmore residence, which I spoke of, we pulled up into the driveway. He got out of the car and he went into the home. I did not go into the house because I did not feel like he was calm enough for us to have a conversation or for us to be in the same house.
Okay, so sorry, I'm so sorry. Just to clarify, so you guys are currently on the drive home while this verbal
With the verbal.
Perfect. And so you get to the home, and Mr. Hicks parks the vehicle, goes inside, and you stay in the car.
Yes.
Okay, great. And I'm sorry, can you continue back?
I stay in the vehicle. I'm watching movies on my phone. My daughter's sitting in the car with me. She's going back and forth into the house. I asked her to bring me my throw blanket out to the car. I was going to stay in the car. Mr. Hicks continued to come in and out of the house to pursue the argument, but I did not feed into that argument. When he realized I wasn't going to feed into the argument, the last time he walked out, he asked for my keys, and I told him he was not getting my keys.
Just to clarify, Ms. Hubbard, the vehicle that you guys, the keys that you're referring to, they belong to the vehicle that you live in? Oh, okay, just wanted to clarify.
House keys.
Okay.
House keys. He wanted my house keys, and I told him no. And that's when he pursued to bang on the window. And I would not open my door. I kept my door locked, but he had to set keys to the vehicle. So he unlocked the vehicle and pursued to get in the back seats of that vehicle. And first it started off as verbal, and then when he wasn't getting the responses that he wanted, they turned into a physical attack.
Okay, Ms. Hubbard, when you say physical, was there, when you say physical, can you just explain to the court, what it is, that you mean exactly?
He tried to put pressure on my neck with his wrist. So when he did that, I struggled to breathe. And at some point, I'm not sure when, I was hit in my left eye, and had to receive liquid stitches in my left eye. I'm not sure when that occurred because it was a bunch of me trying to get him off of me.
Commotion, I understand. Okay, so,
Just for the record, you're pointing to your, kind of like the flat surface of your wrist, correct?
Yes.
Okay, perfect, kind of where the wrist meets the hand. Okay, thank you. And, when you say that he was, putting his wrist on your, you put your wrist on your neck, correct? Okay, in that moment, did you lose consciousness or anything?
I don't believe I lost consciousness. I just know I struggled to breathe and push him off.
Okay, and, sorry, just to back up a little bit, when he was using his wrist, it was just one of his wrists, correct?
Yes.
Not both?
Yes.
Okay. And, could you feel like you could breathe in that moment?
It was struggle, it was hard. It was like, it was restricted.
Okay, so your breathing was restricted. What would you say your vision was like at that moment?
My vision was a little blurry.
Okay.
Everything was happening so fast.
Yeah, I understand that. So what was what was the defendant's demeanor like while all of this was happening?
He was very angry, very.
And was he saying anything while he was doing this?
He did very interesting violence.
And based on that, Ms. Hubbard, and everything else that you testified to today, how would you describe that you were feeling in that moment?
Afraid. I fear for my life even today.
Okay, just one moment, Your Honor. Okay, no further questions, Your Honor.
Suzanne?
Ms. Hubbard, you indicated that, Mr. Hicks had picked you up from work, is that correct?
Yes.
And, he was driving you in the vehicle back to the residence where most of you resided at that time, is that correct?
That's right.
And as he was driving back, he was expressing his concern about not being paid appropriately for services rendered for your employer, is that correct?
Yes. That's right.
And so you indicated that, you did not engage, you didn't have anything to say in response, is that correct?
That's right.
And then you indicated that at some point you arrived at the residence, is that correct?
That's correct.
And Mr. Hicks went inside, but you remained in the vehicle, is that correct?
That is correct.
And at some point, your daughter noticed that you were in the vehicle, so your daughter came and got in the vehicle with you?
That is correct.
And at some point, you asked your daughter to go in and get your blanket or something of that nature, is that correct? And so, at some point, you're indicating that Mr. Hicks came back out to the vehicle and was standing at the window yelling at you.
That is correct.
And he asked for your house keys.
That is correct.
But he had entered the house, right? So he had keys to enter the house, correct?
That's correct.
All right, and so your response to his request for the house keys was no, is that?
That is correct.
Okay, and so at some point, he unlocked the vehicle.
That is correct.
And he got in the back seat.
That is correct.
Now, what type of vehicle is this?
Town and country van.
Okay, so this is a van, and is it fair to say that you have two individual seats in the front?
Yes.
And are there two individual seats in the back, or is it a bench seat?
It's two individual seats in the middle.
In the middle, okay. And so where was he located?
In the back seat on the driver's side.
So he's in the back seat on the driver's side, and you're in the front seat on the passenger side, is that correct? Okay, and so you indicated that at some point, he takes the back of his wrist, if I remember how you wrist, the lower part of his wrist going into where his upper part of his arm is, and he reaches over from the back seat with his back side of his wrist, and he presses on your throat.
Correct.
And from the back seat, from the driver's side, he reaches over to the passenger side.
He put his body in between the two front seats.
And so he puts his hand on your throat, is that correct?
That is correct, his wrist.
And his wrist, thank you for correcting me, his wrist on your throat. And at some point, You struggle to breathe, but you never lose consciousness. Is that correct?
That is correct.
Now, while he's putting his wrist on your throat, at that point, is he saying anything?
He's saying that I should kill you.
Okay. And so, then you indicated that at some point, somehow, you ended up with, cut to or laceration to your eye. Is that correct?
Yes.
But you don't recall exactly what happened or how that occurred. Is that fair to say?
No, I'm not sure how that occurred.
Okay.
It occurred within that moment, but I'm not sure how.
Okay. And so at some point, you get this laceration to your eye, and at some point the police are called and the police arrive. Is that fair to say?
That is correct.
Okay. And Mr. Hicks leaves the vehicle. Is that fair to say?
Once the police arrive, yes.
Okay. But prior to the police arriving, after you had an incident with your his wrist on your throat, did that happen before or after the laceration to your eye?
That happened before the laceration.
Okay. So the throat was first, the laceration was second.
That is correct.
And you're confident all of that occurred as a result of Mr. Hicks?
That is correct.
No further questions.
Any redirect?
Just super briefly, Your Honor. Ms. Pollard, I just want to ask you really quickly, did you receive any treatments for your injuries?
Yes, I went to Sunrise Hospital.
Okay, and that was directly after this incident?
Yes, it was.
Okay, no further questions.
Thank you, ma'am. You may step down. Any other witnesses on behalf of the people?
No other witnesses on behalf of the people, Your Honor.
Any witnesses on behalf of the defendant?
No, Your Honor.
People?
Your Honor, at this time we reserve argument and ask the back over as charged.
Counsel?
Your Honor, I understand that there are two counts to this charge. One is an assault with intent to do great bodily harm, less than murder or by strangulation. The other is a domestic violence aggravated second offense notice. And I would indicate that at this point, I would argue that the prosecution has not met their burden to establish that there has been an assault with intent to do great bodily harm, less than murder, nor by strangulation or a domestic violence aggravated. Ms. Hubbard's testimony was he reached from the back seat, put his wrist on her throat. It's hard to see how somebody reaching from the back seat would be able to put their wrist on somebody's throat. Their wrist only, not that his hand grabbed around her throat, not that he put any grip on her throat, but just merely his wrist was on her throat and caused her to struggle to breathe. I don't feel that the testimony rendered by Ms. Hubbard was credible, and I'd ask that case be dismissed.
People?
Yes, Your Honor. So gripping of the neck is not necessarily an element of the statute of strangulation. But what does need to be met in the strangulation to meet those elements, just regard that someone was in fact strangled and that their breathing was somehow affected, whether it was restricted, whether they lost consciousness. And the complainant in this case did state that she, her breathing was restricted, that she did have difficulty breathing. And I think that given, certain size differences as well, it's not necessarily super shocking that someone from the back seat could apply,
pressure onto somebody else. But with that being said, we don't necessarily need to prove any sort of full hand grip. We just have to prove, that someone essentially, that someone was strangled or choked and that their breathing was in some way affected by that. So with that being said, we do believe that we have met our burden.
Even more so than that, what's important here is what the defendant's alleged intent is or was at the time that he put his wrist or his hands around the complaining witness's throat. She also indicated that he said when he did that, that I should kill you. She said that her breathing was restricted as a result, and I didn't find anything inherently incredible about the witness's testimony. As such, the court is satisfied that people have met their burden of probable cause as it relates to the charges contained in the complaint and warrant. The court finds those charges were committed in the city of Detroit, and the court finds probable cause to believe this defendant committed them. Defendant will be bound over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information date and time will be January 2nd, 2024 at 9:00 a.m. Bond will be continued.
Thank you, Your Honor.
Judges, two things I want to address before. First, I didn't hear the date of the arraignment. What date did you say, Judge?
January 2nd, 2024.
Okay. Your Honor, it is my understanding that this was Mr. Hicks' home in which this alleged offense occurred. It is my understanding that the alleged victim is no longer at the home. She has left the home. I believe when we had the PCC, she acknowledged that she had left the home. I'm asking that my client be able to return to his home at this time.
And Your Honor, Your Honor, if that's true, the people have no objection to that. However, APA Shelley Drain did just go ask the complaining witness if that is in fact true.
Okay, give us a second. We'll verify that.
Okay, and the other issue is when I was at the PCC, I asked for my client to be able to be go to work Monday through the weekend, actually 6 to 6. The court agreed to 6 to 5 Monday through Friday. That prohibits him from working on Saturdays and Sundays while he's doing his home repair work. He's asking to be able to do home repair work on the weekend as well.
Okay, Judge, we have an update. The complaining witness in this case did state that all of her belongings are in this home. So if she could just have 72 hours to just retrieve her mail and some of her belongings, then yes, we would have no objection to the defendant staying there for 50 days.
Counsel, you okay with that?
72 hours is fair for her to get her things.
Okay. Send over a proposed order to that effect. As it relates to him working on the weekends, he's doing what? Home improvement.
Yeah, he has his own business, Your Honor. I had addressed this at the probable cause conference, and you had given him 6 a.m. to 5 p.m. Monday through Friday, but sometimes he's doing home repair on the weekends as well when he's trying to finish up a job. And so he's not able to go on the weekends because you only gave him Monday through Friday.
People?
Your Honor, the people don't have any objection if he's trying to get to work.
All right. Give me an order to that effect as well.
Okay, thank you, Your Honor. I'll send it over.
All right, thank you.
If I don't see you anymore, enjoy your holidays.
Thank you. Same to you.
I'm not threatening you. Say one more word and that's 30 days. 30 days.